Chapter 2 deals with an overview of the U.S. legal system. We'll go through this kind of quick. It is a lot of slides. I just don't want to overwhelm you with a lot of information. So the first few slides are just your learning objectives. You're welcome to go back and look at those. And then your book talks about the U.S. legal system and its operation, what the primary goals of the framers of the Constitution when they were trying to build our legal system and build that foundation for our legal system. Their goals were to have liberty, freedom, and fairness for everyone. We'll also go over different categories of law and the court system and its officers. So over time, we've had different purposes of why we have law and why we use law to regulate the people in this country. The first reason that we have is to protect society's interest. If you own property or own anything, laws can help you protect those possessions. Laws are also there to deter antisocial behavior. If we see some sort of behavior in people or a group of people or a person, and society as a whole does not like that behavior, we have created laws over time to deter that particular behavior. For example, texting and driving. As that became more popular, society as a whole said this is causing a lot of traffic problems. We need to try to deter that if possible. And so the texting and driving law was created. Laws are also there to enforce moral beliefs. Laws are created to enforce the beliefs of the majority of the society. So if most of the society holds the moral belief that it is wrong to cheat on a spouse, then a law will be created to prevent that. And in fact, a law in North Carolina does exist that makes it illegal to cheat on a spouse. Laws are also there to uphold your individual rights. The laws are there to support those in power. They're there to punish lawbreakers. So you'll see if you ever look at some of the general statutes, there are going to be consequences contained within those particular laws that tell you what will happen if you do in fact break that particular law. And laws are there to seek retribution for any wrongdoing. There are two theories about the purpose of the legal system, the consensus theory and the conflict theory. Consensus theory holds that individuals in a society agree on basic values and what's inherently right and wrong, and that laws express those values. So as a society, we all basically agree that killing another person is wrong. That's inherently wrong. We agree that raping an individual is inherently wrong. And so we have laws that express those values. There's also a social contract where individuals agree to give up a portion of their individual freedom to benefit the security of the group. As a whole, we may give up some individual freedoms in order to protect our society as a whole. And the second theory is going to be conflict theory. And that holds that laws are established to keep the dominant class in power. And this explains how laws protect the interests and values of the dominant groups in society. And so if you get a more powerful group that exists in society, they tend to be able to create those laws and enforce them against the non-dominant class that exists in society. The purpose of the criminal justice system is a lot of times discussed in terms of the crime control model and a due process model. The crime control model just emphasizes the repression of criminal conduct, trying to stop criminal conduct. It basically says that the criminal justice system is there to bring criminal behavior under tight control. We want to eliminate as much crime as possible and as much criminal conduct as possible. The due process model emphasizes more the rights of the individual, and it rests on the presumption of innocence. We want to make sure that anyone going through our criminal justice system receives a fair and just treatment as they do so. And individual rights are not sacrificed for the sake of efficiency in the due process model. This is where a lot of your amendments that are found in the Bill of Rights come from or come into play. So our basic purpose for our legal system in the United States is just to ensure fairness in balancing individual and societal rights and needs, but also prevent excessive government power. And it's hard to do. It's hard to find that balance. And the scales of justice tip one way or the other a lot of times. You have to constantly keep changing the criminal justice system in order to keep those scales balanced. It's a fine line, and over the years you'll see it's like a pendulum. It swings one way towards individual rights, and another it'll swing towards societal rights. So it's a fine line that we walk to try to keep that balance. The case Roe v. Wade has been in the news a lot lately. I'm sure if you've seen the news, you've seen something about it. And what Roe v. Wade deals with are individual rights concerning abortion. In the first issue the court dealt with, do abortion laws that criminalize all abortions except those required on medical advice to save the life of the mother violate the Constitution of the United States? And also, does the Due Process Clause of the 14th Amendment to the United States Constitution protect the right to privacy, including the right to obtain an abortion? And what the court said back in 1973 was that yes, state criminal abortion laws that do not take into consideration the stage of pregnancy and other interests violate that Due Process Clause of the 14th Amendment. And they also found that yes, the Due Process Clause protects the right to privacy, including a woman's right to terminate her pregnancy against state action. But that was in 1973, and as we all know here recently, the Supreme Court took up another case, and that holding is essentially reversed. How our laws were developed and the definition of law in general, most of our foundation for law came from early English law. We took a lot of how we modeled our criminal justice system from European and English law. And so early English judge-made law was based on custom and tradition, and it was called common law. We still have a lot of things that we refer to as common law here in the United States. But in this circumstance, royal judges traveled through territories to apply a broader or national norm as cases were decided. So because everything was so spread out, it was not a central court that you would go to. The judges themselves traveled and tried to be as consistent as possible throughout the country, making the law more common as they went. Common law depends heavily on precedent, which are just prior cases, and the doctrine of stare decisis, which means let the decision stand. What the court does, they look at older cases that have already been decided that have similarities to the case in front of them, and they follow the instructions or the holdings from those previous cases. And this helps to ensure consistency in the law. When things change is when you have a circumstance or a bit of information from the new case that is different from any previous precedent that the court has to look at. In that situation is where we get new law created. The Constitution's purpose is still the same. It's there to ensure individual liberty by limiting government power. It controls government by restricting how and when the government can and cannot interfere with citizens' lives. Excuse me. Human nature will dictate that different needs are perceived at different times, and effective law should be flexible enough to respond to these changes. American law is often referred to as a living law because it's not stagnant. We don't have the same laws that we had 200 plus years ago when this country was created. Our laws have changed, expanded, been repealed to serve the overall system. As society changes, as times change, as technology changes, our laws have to keep up and change as well. And that's why we call it living law, because we do try to mold and change and rework our laws to fit where we're at currently. Law can be categorized into a few different major categories, and the first one is going to be statutory law. These are laws that are created by the legislature or the governing body. These are the general statutes that you see in North Carolina. If you were to look them up, they fall all under the general statutes. If you look for the federal law, they are the United States Code. And this can also be referred to as codified law. It's set forth in an organized, structured code They are numbered. You can find them easily. They're incredibly organized. If you ever go to the North Carolina General Statutes website, you can look through them. They're by chapters and then by code. An ordinance is a law or a code established at a local level. So if you have city ordinances, those are not going to be state laws or general statutes created for that particular state. They only apply to either that county, that municipality, that town level. No statutory law can violate the Constitution. The Constitution is the greatest law that we have, and anything created below that must follow the Constitution and cannot violate anything contained within the Constitution. The case Marbury v. Madison from 1803, Mr. Marbury was a justice of the peace in the District of Columbia at the end of John Adams' presidency, but his last minute appointment was not fully finalized, and so he invoked an act of Congress and sued for his job. Basically, the paperwork didn't get pushed through in time, and so he sued to have that job. And the issue the court looked at is the Supreme Court the place for Marbury to get the relief he requests. And the court said the Constitution was the fundamental and paramount law of the nation, and an act of the legislator that is repugnant to the Constitution is void. When the Constitution, the nation's highest law, conflicts with an act of the legislator, then that act is invalid. It basically gives the Supreme Court its power of judicial review. This slide discusses the difference between crimes and torts. Crimes are going to be criminal wrongs against the government and the people that it serves. So if you ever see a criminal case, it will either be the state of North Carolina or the United States versus the defendant, because the government or the state is going to be the injured party in that situation. And examples of crimes are going to be things like murder, rape, robbery, etc. These are also called penal codes or criminal codes or laws. A tort is a civil wrong by one individual against another. You have something like child support, eviction, divorce, anything other than contract law in civil litigation is going to be a tort. And so you have one person or one corporation versus another person or another corporation. And sometimes there is overlap between criminal and civil law. If you remember the O.J. Simpson case, he was criminally accused of murdering his ex-wife and her boyfriend. He was found not guilty in that situation, but he was also sued civilly for their deaths by their family as well. He was found responsible in civil court for those deaths, where he was not found responsible in criminal court. Another example, if a drunk driver causes a crash and hurts an individual, is it criminal or civil? It's both. They can be guilty of a DUI, which is a crime, and they can also be held civilly liable for the injuries caused to the others because of the tort that they committed, that car accident. The government would pursue the criminal charges, and then the victim in the car would file a lawsuit and pursue those damages for their medical bills, car repair, whatever injuries they faced. A legal citation is a standardized way of referring to a specific element in the law. There are three parts: the volume number, an abbreviation for the title, and then a page or a section number. So the case Miranda v. Arizona that everyone is familiar with, the citation for that is 384 U.S. 436, and it's from 1966. If you were to put that citation in, you could pull that up on Google very quickly, and it would bring up Miranda v. Arizona. A string cite for that case would be Miranda v. Arizona with the 384 U.S. 436, 86 Supreme Court SCT 1502, 16 LED 694. It just tells you which books or what record that particular case would be found in. A legal opinion usually contains a fact section that gives us a brief fact of what the case is about, a statement of the legal issues presented, and typically those will start with something like whether this or that. They're usually whether statements. Then it will have a discussion of the relevant rules of law and how those apply to those issues. And then the court will issue a holding or their decision and their opinion on how those rules of law apply to this particular case. And they may also discuss the policies and the reasons that support that holding. And that holding is the rule of law applied to the particular facts of the case and the actual decision. The court may either affirm, which means they support, they may reverse or overturn, or remand to return the case to the lower court. Generally, if they support, they don't remand, but sometimes they can for minor issues. A case brief is an outline of a legal case. It will have the case name and the citation, again, a short summary of the facts, the legal issues that are involved, again, a whether statement typically, what was the court's decision, what was the reason for the court's decision, and were there any separate opinions or any dissents from any other justices or judges. The reason that we cite a case is to use references so that other legal researchers can easily determine whether the original holding has been changed through any appeals. Once you find an opinion, you have to do something that's called shepherdizing and find if any other court cases have come out since that case to overturn or change that original opinion in any way. Because if you do rely on a case that has at some point been overturned or rendered invalid, it could be disastrous for your legal argument because that opinion is no longer valid with the court. There's been something newer that has come and is more valid and is the current law. Our court system in the United States has two main functions: settle controversies between parties and decide the rules of law that apply in the specific case. Article 3 of the Constitution establishes the federal judicial system. And the type of cases a court can hear totally depend upon its jurisdiction. And a jurisdiction is what cases can that court hear. They can be jurisdiction over the person or jurisdiction of the place or the idea or the type of case that is being heard. Our U.S. judicial system is two-tiered. It consists of state and federal court systems. And at either tier, there are typically 3 levels. You'll have the lower court, which is the trial court. At the federal level, that's the U.S. District Court. At the state level, that is just your average court that you see at the county level. And then you will have the appellate court. At the federal level, that's the United States Court of Appeals. North Carolina is in the 4th Circuit. At the state level, it's the North Carolina Court of Appeals. And then the Court of Last Resort. For the federal system, that is the United States Supreme Court. For North Carolina, it is the North Carolina Supreme Court. The levels exist to assure that if either side thinks procedural rules were violated, they can appeal to a higher court and potentially have a change of outcome. The different types of jurisdiction: original jurisdiction. If a court has original jurisdiction over a case, they can hear and try that case and they can render decisions on that case. If a court has appellate jurisdiction, all they can do is review legal issues of that case. They don't look at factual issues, they only look at legal issues involved in that case. If a court has general jurisdiction, then they can hear a wide range of cases. Most of your state courts have general jurisdiction. They can hear traffic cases, criminal cases, divorces, child custody, civil litigation. That's general jurisdiction. Exclusive jurisdiction, a court can only hear specific cases. Our bankruptcy court at the federal level has exclusive jurisdiction and they can only hear bankruptcy cases. If courts have concurrent jurisdiction, that means 2 or more courts can hear the same case. A lot of our criminal charges will have concurrent jurisdiction. They can be heard at both the state level and the federal level depending on what the charges are. Okay, we have covered that. So who are the officers of the court? Initially, you have your judge, who sits higher up than just about everybody in the courtroom. They typically have a black robe on. At the federal level, they are appointed. At the state level in North Carolina, they are elected. In North Carolina, they serve for 4 years, 4-year terms. South Carolina does things a little differently. I think there's appointments there as well. Next, you have lawyers who are in the courtroom. You will have, if it's a criminal court, you'll have lawyers for the state who are called district attorneys or assistant district attorneys. They are prosecutors. And then you will have defense attorneys. In civil court, you'll have defense attorneys and plaintiffs' attorneys. On the defense attorney side, you could also have a public defender who is appointed to represent criminal defendants for defendants who are not able to afford to hire a private attorney. Also within the court, you have the clerk of the court. This person is charged with maintaining the records of the court. They keep the minutes of what is going on. They keep up with the judgments and the forms and anything that happens within that court, the calendar and everything like that. They are not to be confused with the court reporter. The court reporter is the person who sits and records word for word everything that is happening in that particular case. They transcribe things. Those are 2 different people and have 2 different jobs. Also, within the court, you have, and all these last 3 basically fall under the same category, sheriffs, marshals, and bailiffs. At the state level, the sheriff's deputies are the ones who are maintaining order within the court. At the federal level, it will be the U.S. Marshals. They are sometimes all referred to as bailiffs. There are doctrines that govern what cases will be heard and can be heard. In order for a case to be heard, a person who is filing the case must have standing, which means they have to have an actual interest in the matter of dispute. You can't just sue someone on someone else's behalf without you yourself having an interest in the matter. So if you witness a car accident but you're not hurt or injured in any way, you can't just go sue for one of the other folks who were involved in the car accident. You yourself have to have an actual interest. A case also cannot be moot. So if the issues that gave rise to the case have either already been resolved or they have been disappeared, then that case cannot be heard. It is moot. So if there are no issues left in the case, then it cannot go forward. Also, a case has to be what we call ripe. If a case comes to court too soon, it is not ripe. It is not ready to be before the court. So you have to wait on that case to be ripe enough to come to court, which means the court can't get prematurely involved in a case that could potentially be resolved through other means. A lot of administrative cases, you have to wait for them to be ripe to get to court. Social Security Administration type things, you have to file with them. EEOC type cases, you also have to go through all their administrative efforts before you're allowed to bring it to the court level. The courts are only one component of our American system of justice. There's law enforcement, there are correctional systems, and if you guys have taken more than one class in criminal justice, you know that. There are the 3 branches of our American justice system. Law enforcement officers are known as the gatekeepers of the criminal justice system. Correctional officers handle the offenders after they have been found guilty of a crime. And then we also have the juvenile justice system, which is made up of the same parts. We just use different terminology when we refer to the folks involved in that system. Comparative law is the study of comparing and contrasting laws, and that is comparing our United States laws to other countries' laws. The International Criminal Police Organization is also known as Interpol. And this also deals with the treatment of any military prisoners if they're in a foreign country.